Hey, what's up? This is the gag order hearing after today's arraignment. Bring it up and I'll start it. Mute myself. All right, here's the gag order hearing real quick.
The ability to find a so-called impartial jury.
This is the gag order hearing. Let's listen in live. Walt will let you go. Thank you so much.
Thank you. It was a pleasure.
Yeah, the screen is muted. Okay. Now let's open it up. Okay. Say something, Mr. Perone. Still, I don't know. Technology's great until it's not. Okay. Are your speakers all the way out, Mr. Perone? Tap it or hit it. Whichever you prefer. Just kidding. Do we have tech people who take care of this?
JB here with you in the Stream Center. Just wanted to let everybody know I'm boosting the audio just a little bit so that hopefully everybody can hear, but this is the raw audio being boosted a little bit out of Idaho. This is, again, believed to be the gag order hearing out of Idaho.
Somebody is trying to fix that? Ms. Excuse me, can I hear you now? Say something. Oh yeah, what I can do is should I just move mine up? And that will pick it up. But then we'll have a big echo. Obviously, I am not very skilled at such things. Okay. Really sorry for all the delays. There were other things going on before I came into court, and now we have this. So thank you for your patience. Okay, while we're waiting for that, I'm going to recognize Mr. Gray, who's representing the Gonsalves family. My plan was to go through the variety of motions that each representative has, starting with the Associated Press, then going to the Gonsalves family, and then to the party's council, and we'll see where we go. But we're not going to have an 11 o'clock because we're just going to take care of all the scheduling issues now in this hearing.
Thank you, Your Honor.
Thank you. Yeah, let's go off the record until we can fix this. Thank you. Okay. say something, Mr. Perone? We're off the record. Don't worry.
Mr. Corral.
Fine with me.
Okay. So go ahead and do that.
So I'm gonna unmute myself.
I'm gonna unmute.
Huh?
Okay.
Okay.
Can everybody hear me?
Yes, Your Honor.
And I can hear you, Mr. Perone.
We
We
got
have
an
an
echo
echo
now.
now.
This is more than
More
my
than my
outside
outside
voice.
voice.
Okay, is that better? Oh, brilliant. Thank you, Mary Lynn. Okay, thank you, Jennifer. Let's get back on the record then. Back on the record, State versus Bryan Kohberger, CR 29222805. I was explaining how the order and the scheduling conference might go, at least my plan. And so I'm going to start with you, Mr. Corone. Your clients have the motion to vacate the amended non-dissemination order filed May 1. Also the motion to intervene filed May 1, same date. And now this case is in my hands, so I need to set a hearing. And I'm wondering how far out. I'd like to get some briefs, and this is a message to everybody before the hearing, including I want to hear arguments about whether or not there should be cameras in the courtroom in a high-profile case like this one. So, Mr. Corone, what looks good for you? And let me throw out, knowing that a lot of you were prepared to be here the week of June 26th, that might make sense. But I'll hear from you, Mr. Corone.
Yes, Your Honor. So with our motion to vacate, motion to intervene, we've briefed the merits issues there. I think as the court's aware, we also briefed those issues before the Idaho Supreme Court. So I would think we could be ready to move pretty quickly. We have not briefed the issue about video cameras in the courtroom. So if that's something that you'd like the media coalition to weigh in on as well, we would need to submit a separate brief on that, but we can do that in the week of the 26th. The 26th itself, I'm not available, but the rest of the week would work.
Excellent. And I'll tell you, the reason that I'm bringing up cameras in the courtroom is because if I address that issue, and I haven't let you all know that that might be an issue, then I'm going to get a lot of grief for not allowing you to brief that issue. So that's why I'm giving you an advance notice on that. How do you feel about the afternoon of June 27? Given what's happening just quite recently, we might want to do that in person. I'm willing to do it remotely, but then we have to, there are a lot of different interests and different people who want to weigh in on that, so it might be better to be in person. But does that work for you? Say starting at 1:30, June 27, Mr. Corone?
Yes, Your Honor, that works for me. And Ms. Olson and myself can both come in person. We would have been there today in person, but we found out about the in-person option on Friday, so I apologize for using Zoom today, but we can certainly be there in person. If the court's anticipating hearing from witnesses that day to hold an evidentiary hearing, there may be some witnesses that would want to appear via Zoom if that's okay with the court. But I'm not sure if that's even something you're contemplating. I'm just flagging it in case you are.
Well, let me put it this way. It's your motion and others' motions. One of the complaints that I've seen in the briefing is that there's no evidence in the case supporting any of it. You know, we're all kind of moving forward on supposition, I guess. And some of it is obvious, but I think that would be wise. I suppose you could just file declarations, and that's what's been doing, how that's been going. If we're going to have a lot of testimony, I might want to move this back to 10 a.m. just to make sure that we have enough time to get things finished that day. Would that work for you?
Sure. So our position on the evidentiary issue is your summary was correct, that we don't believe that there is an adequate factual record at this point. Given that it is our motion and it's based on the record that existed when the order was issued, procedurally, I'm not really sure there is an opportunity for additional evidence to be put forth. I only brought that up because I saw in Mr. Kohberger's opposition to our motion for reconsideration that there was a mention of an expert witness. If that evidence is going to come forward or other evidence, we of course would want the opportunity to cross-examine that individual or whatever individuals might be testifying. But you know, as things currently stand for the record as it exists and the evidence that the Media Coalition intends to put forward, we included a declaration with our motion. I'm not sure there's really need for us to put on additional evidence, but if that's something the court was going to hear from the state or Mr. Kohberger, then I just wanted to bring that to the court's attention.
Thank you, Mr. Corona. Of course, you'd have the opportunity to cross-examine any witness. All right. Well, we'll stay at 1:30 then. So now, Mr. Gray. So I'm thinking that maybe we should keep these things together and do them the same day if that works for you and your clients.
Well, Your Honor, I see the issue very clearly different from the AP's motion versus my motion. I think their motion is more of a getting rid of the non-dissemination order, the gag order. My motion is a motion to amend and or clarify some of the issues in the gag order. They have a lot of constitutional different issues that we have. I have some issues that I think are very separate. So I would request a hearing on my own much sooner. I think the court's aware I filed this motion in February on this case, and there was a massive delay based on the fact that previous Judge Marshall was waiting for the Supreme Court to get some clarification regarding the AP's motion that she filed with the Supreme Court. So I'm ready to go when the court's ready to go, but I think our issues are very, very different than that of the AP's motion on this case. So I would request a hearing much sooner I can do it by the end of this week.
All right. Well, and I recognize this was all pretty short notice for everybody. And I don't know if, let me go to Mr. Rudley and then Mr. Logsdon, because they're going to weigh in on that motion as well, I'm assuming. I'm thinking about maybe June 9th would be the soonest I could do this, but let me go to you, Mr. Logsdon.
Your Honor, we'd be ready to go and would expect to put on an evidentiary presentation that week of the 26th. To the extent that Mr. Gray wants to have his motion heard ahead of time, and just based on what I've read in it, I mean, obviously, if the court were to agree with some of the things that he says.
Into the mic, I guess.
Sorry. Obviously, if the court were to agree with some of the things that he says and winds up amending the order, that could change everything for everybody else. So to some extent, I think it actually is probably better to do them all at the same time, so the court isn't in piecemeal changing what we're all arguing about, but I would be ready for the 9th if the court chose to do it that way.
No judge likes to do things piecemeal. But I also understand that Mr. Gray and his clients have been waiting for a long time now. It's not anybody's fault. It's just how that came down because the Associated Press et al. Went straight to the Supreme Court in February, early February, and that would trigger a delay, which it did, and it was important, I think, for Judge Marshall to get the direction from the Idaho Supreme Court before we start, chipping away at each order. I don't know if would you be. I mean, I'm okay setting it for June 9th, Mr. Gray, but you may have some testimony happening. You may want to wait until you hear what everybody else is saying. It's likely that there's going to be some adjustments, you might say, or clarifying in the order. Partly in my reading of the Supreme Court's decision. Maybe I'm reading too much into it, but there were some hints maybe of what the trial court might want to consider. Okay, go ahead, Mr. Gray.
I was going to say, since this is your gag order now, this non-dissemination order, Your Honor, and in reading my motion, if the court does want to consider making some of the modifications that might have been suggested in my motion, my motion may end up being moot. I think some of my modifications and or clarifications to the non-dissemination order are fairly minor, but allows, and I think the Supreme Court did give some guidance, which I think added weight to my arguments and my motion. So it's not above the court to take a look at my motion as well as any other motions that have been submitted to the court and modify the non-dissemination order, allowing for some of the issues that I discussed in my motion, and then you would only have the AP who are attacking, I think, the gag order as a whole, the non-dissemination order as a whole. I'm just addressing a couple of clarifications and amendments that would allow myself as an attorney to speak on behalf of my clients that regarding the non-dissemination order, and I think it's your order now, so you're more than apt to be able to go and make those changes, and then we wouldn't have an issue with the non-dissemination order at all. So I don't think so. Obviously, the 9th, I'd like to keep the 9th because my issues are very small and narrow regarding the non-dissemination order. But if you were to make changes to those ahead of time that I was able to review and it was acceptable, I would withdraw my motion, Your Honor.
Okay, thank you, Mr. Gray.
Thank you.
Well, it would be highly unlikely for me to change the order before I hear from counsel, because I don't want to, third, fourth, fifth, sixth. I only want to do this once, and I'm happy to set it for June 9th, maybe 10:30. Does that work for you?
That does, Your Honor.
Okay. Does that work for you, Mr. Rudley?
Yes, Your Honor, it does.
Okay. Mr. Logston?
Make it work, Judge.
Okay. Let's do that in person. Okay. So now we have the June 9th at 10:30. We also have the Associated Press et al. On June 27th at 1:30. I think that works for you, Mr. Rudley?
It does, Your Honor.
Okay.
Yes, Your Honor.
Okay, excellent.
Your Honor, may I speak?
Yes, Mr. Corona.
Your Honor, I apologize. I may have misunderstood what you said earlier. I was understanding that the week of June 26th was when the court was first available, but if the court is available to hear our motion earlier, we would be available on June 9th as well. I know that our most recent motion is pending more recently, but obviously we've been challenging this since February as well. And it's our position that the non-dissemination order violates the Associated Press and Media Coalition's First Amendment rights. Those constitutional violations are irreparable. So we would like our motions to be heard as soon as possible as well. And I suggested otherwise by agreeing to the week of the 26th. That was simply because I misunderstood that was when the court was first available.
Thank you. Only one thing I'll say about that. Irreparable harm goes both ways. And so I was a little bit troubled by that claim without considering the Sixth Amendment considerations. I mean, you know, this is a balancing, the law is clear on this, okay? It's a balancing test. And when your client says that it's arguing it as the First Amendment is absolute, is also troubling. So I would suggest that maybe the Associated Press needs to tone it down, just ratchet down a little bit. Because some of the arguments, including the first line in the motion to intervene, says that the Supreme Court held a certain thing, that I do not think that is what the court held. And you know the difference in a holding of an appellate court. So I just felt obligated to help you out a little bit in terms of what the Associated Press is asking for. And in the meantime, there's a lot of potential irreparable harm from media that is affecting a fair trial. So that is really concerning. This is a very high-profile case. So I'm happy to set this on June 9th, too. Okay, how about we set yours at 1:30 though, so we don't kind of push them all together. Does that work for you, Mr. Rudley?
It does, Your Honor.
Okay, does that work for you, Mr. Logsdon?
Mayor, I don't know if we'll have an evidentiary presentation ready by the 9th. That would be my only concern. We can certainly try. But
Well, let's see, and if that doesn't work out for you, then
we'll let you know.
we'll talk about it. Okay, I just felt the obligation to talk about irreparable harm. Okay, there's a lot of interest here, Mr. Carone, and I think my job, my constitutional responsibility is to consider all of the potential irreparable harms, or all the injuries, or all the harms. So, you know, I just want, maybe it's appropriate, I was just thinking, you know, I just want to remind everybody, okay, on this particular issue, but all issues, at all times, that we all, okay, judges, lawyers, journalists, media generally, have constitutional responsibilities to both the First Amendment and the Sixth Amendment. And what I generally am seeing in the newspaper and the media is no discussion about the importance of the Sixth Amendment. It's just the First Amendment, which is very important. But here's the real reminder. The first sentence of the preamble of the Idaho Rules of Professional Conduct says that a lawyer, as a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. We all have that responsibility. And sometimes we push in a hard way for our clients, and that's appropriate. But you have larger responsibilities at the same time. Okay, so we got a hearing 10:30. That's for the Gonzalez family with Mr. Gray. 1:30 is the Associated Press et al. With Mr. Carone. And I think that deals with all the pending motions. For you, Mr. Gray, you articulated what your motion is. So we've addressed that.
Thank you, Your Honor. Yes,
Okay.
yes, Your Honor.
You're welcome. And Mr. Carone, those two issues that are still outliers on your clients, I think that's all we have. The motion to vacate the amended non-dissemination order and the motion to intervene. Anything else that we need to address for your clients, Mr. Carone?
No, Your Honor, unless you mentioned the broadcasting issue as well. I'm not sure if you're going to set a separate briefing schedule for that. Obviously, for the motions, they'll follow the briefing schedule wasn't going to follow that. I just didn't know
Yes.
when exactly you wanted that briefing.
I'm going to send a briefing schedule out for everybody. And now, okay, if we're going to do it on June 9th, you don't have very much time to do those briefs. So that's why I was thinking it made a lot more sense to do it at the end of June. But if you all think you're ready to do that, I'm willing to hear it. But I want those briefs. We'll say by June 2nd. Response briefs will be due by June 6th. And any reply briefs due by June 8th. So that's going to be rapid briefing. I'm just trying to accommodate everybody. Okay? I got a lot of interest floating around on these issues. Without forgetting Mr. Kohberger, who's primary in this case right now. All right, so let's move to, and I mean, anybody who's here for Associated Press or Gonzalez family can be excused if you'd like. We're also happy to have you stay. No problem.
Thank you, Your Honor.
Okay. Thank you. Okay, thank you, Mr. Farrell. All right. So what we have now between the parties is motion to compel, which we're moving out. That was kind of a on and off hearing. Disclosures of grand jury materials while protecting those materials from the public. Extension time to file pre-trial motions after receiving materials from grand jury. I believe those are the motions that we have outstanding. Is this, are you arguing these or scheduling these, Ms. Taylor?
Your Honor, we can schedule all of those hearings.
Okay, when do you want to do this?
Your Honor, I think that if the court has June 26th, we can do that. We will be ready to address that round of motions on June 26th.
Excellent. We'll have that 1:30 on June 27 because the Associated Press moved that to the 9th.
June 27th is just fine for us.
Okay, perfect. Well, 1:30. Okay. Is there anything else we need to address today, Mr. Rudley? Mr. Thompson?
Your Honor, I think the June 27th should work fine. For whatever reason, our office hasn't seen copies of the grand jury pretrial motions, but I think there was a miscommunication. Those will be coming. We'll be prepared.
Okay, great. And certainly if those issues are resolved between counsel, then we won't have to have a hearing.
Yes, sir. Thank you.
Okay, so anything else we need to address today, Ms. Taylor?
No, Your Honor, thank you.
Okay, thank you. Mr. Watson?
There, thank you.
Okay. Great. So I think Ms. Masseth has been observing on Zoom. I just wanted to identify her, and also Ms. Let's see. Oh, I guess Ms. Beatty is too. So anyway, there are other people on the Zoom. So thank you. Okay. Anything else then? No. Okay. Thank you all.
Thank you,
We
Judge.
are adjourned.
Bryan Kohberger exiting this hearing, two hearings that were on the court schedule, one for the gag order, the other for the motion to compel. And that was the pool camera feed, feeding that out to the media. JB here with you live, folks, on WFLA Now. Good to have you back. That's a live shot from outside the Latah County Courthouse. Joining us now live, I want to get right to him. You know him because his name is quite literally the lawyer you know. Peter Tragos is back with us here on stream. Peter, you and I did a lot of conversation about the Idaho murders at the University of Idaho. We did a lot of conversation about Bryan Kohberger and the legal situation surrounding him. Let's just dive right in. We're going to start to take your questions, folks, out of the YouTube, Twitter, Facebook Live comment sections, TikTok as well. Hashtag KJB. Hashtag lawyer, you know, as we let those comments come in with those hashtags so that we can animate them on screen. Peter, your perspective as far as what has unfolded so far today. Bryan Kohberger being arraigned, standing silent, the judge entering a not guilty plea. And now we have a trial date for October 2nd.
Yeah, I mean, there's a lot that's happened today to unpack already. Just starting with the arraignment, the choice to stand silent. It is a choice. It is not the norm. You would think if you want to claim you are innocent, that you would say, I am not guilty of these charges. We've heard that in other cases. Specifically, Murdaugh pounded the table, continued to throughout the entirety of his trial, even after he lost. Many people do it, even after they lost. And right now, Bryan Kohberger has decided not to do it when it's the most public time to say that he is not guilty. It could mean absolutely nothing. Or it could mean maybe we are going to work towards a plea deal or something is happening behind the scenes that we just don't know about yet.
Peter, I just want to bring up the very first comment that we have from our audience. And it's from Lissy, who says that we're neutral and unbiased as far as covering this case. We really appreciate a lot of the appreciation that we get on YouTube. Peter and I have seen a lot of the comments that have come in over the last 5 months. We have not talked about this case, Peter, since January, but a lot of people do, of course, appreciate just some of the interaction that you and I have, and then, of course, the interaction that we have with our audience. So let's start to get into some of the hashtag KJB, hashtag lawyer, you know, questions and comments. And it starts here from SH. Hashtag lawyer, you know, when will we know if the prosecution is going for the death penalty?
So I think today was so important as the arraignment and his not guilty plea, because it started the clock on a couple things. It starts the clock on the state's ability to file a notice of intent to seek the death penalty in Idaho. They have 60 days from today, and it triggered his speedy trial. 6 months from today, they have to set his trial, which is why the trial date, I think, is October 2nd or sometime in early October, which is near the end of the speedy trial period, which I think is also interesting that the defense chose to kind of kick it out as much as they could without waiving speedy trial, which I think is the best case scenario here and exactly what I would do if I was the defense attorney on this case. It gives yourself as much time as possible because they can still waive it anytime they want. They can show up on October 7th, ask for a continuance, waive speedy trial, and then kick it down the road. Or if they want to keep the pressure on, they can push the state to get that case tried on October 2nd.
You know me, I like to put you on the spot, Peter, with percentage chances. I've done it a lot of times on our previous live streams together. Percentage chances that this actually begins in early October.
5%.
Wow, that low.
Yeah, I think they do not seem to be pushing the envelope on this case. They waived his speedy preliminary hearing. I think they've been working in the background with the state, working on discovery issues. they wanted to delay this gag order hearing. They have to prepare. They have to get things ready. That's another thing that's going to take another month of work, that they're not working on the case because they're working on the gag order. They push it till the very end of the speedy trial period. So anything happens and they have to extend it basically at all, the judge is going to ask, are you agreeing to waive your speedy trial right? Because if they file motions saying the state refuses to give us this stuff, or they file motions doing anything to delay the case, they're going to have to waive their speedy trial. And I think that that's probably the likely scenario at the end of the day, but things could change over the next 6 months.
We will be paying very close attention. A lot more to go over with Peter Tragos. For those of you refinding the live stream, perhaps you saw the arraignment earlier here in the center of your screen. Maybe you're coming back to YouTube Live, Facebook Live, TikTok Live, or WFLA.com. We're on here live with Peter Tragos, the lawyer you know, who has done a lot of different live streams about Bryan Kohberger and, of course, the University of Idaho murders. And I'm sure that he will have live streams in the hours, days ahead as well. Let's go to this one from Brianna. Hashtag lawyer you know. Do you think Bryan's silence is likely at the advice of his lawyer for the sake of the court, or excuse me, for the sake of the court of public opinion?
Yeah, I think that's a really good guess, which is all we're doing at this point. But by doing anything outside the norm, they know people are going to talk about it. Okay. It's not a surprise because he could have just said not guilty. That's what everybody was expecting. People that think he's guilty in the media or in the court of public opinion are still going to think he's guilty, even if he says not guilty. People that think there's something fishy going on, he probably didn't do it, they're still going to think that if he says not guilty. It wasn't really going to change anybody's perception if he would have just said not guilty. That's what everybody expected. But doing something different is interesting. My guess is it could have been on the advice of counsel because we know the gag order arguments, we know the media attention, we know the public concern and interest in this case is high. So maybe she just said they're going to pick apart every word you say, the way you say not guilty. If it's too soft, if it's too strong, they're going to pick you apart for that. So just say nothing. Effectually, legally speaking, it's still a not guilty plea, and let's just keep the case rolling.
Very interesting. And he did voice words today in responding to the judge. So it's not as if he didn't want to speak, because he was listening for the prompts of when to speak, and then he chose to speak when Judge asked him various questions over the course of the arraignment. However, that moment he chose to stand silence as far as the moment when it was time for him to enter a plea. I want to go to Team Brittany here, who's one of our great moderators on the WFLA YouTube page. Even our moderators can ask questions. Of course, they're very much part of the process here, what we do interactively on WFLA Now. Hashtag lawyer you know. If you have a moment, could you explain to the chat what you spoke about the other day as to wording, may and could versus does, as it relates to a person having exculpatory evidence?
Okay, so there's a lot to unpack here, and depending on whether we're talking about the grand jury or anywhere throughout the process, but during the discovery questions and some statements made by the defense, you will hear them say there may be exculpatory evidence here that the state hasn't turned over. That does not mean the state is hiding exculpatory evidence. The state has already once in this case said that they are turning something over because they want to make sure they're within the Brady. They don't make a Brady violation, which would be a discovery violation, withholding exculpatory evidence. So the state knows if something like that comes up, they have to provide it to the defense. So it doesn't seem like they're hiding anything, but in order to highlight the importance of certain documents or certain videos or certain audio recordings, the defense will sometimes say, Judge, there could be something exculpatory in here. We need the state to produce it, and we need them to produce specifically this so that we can listen, watch, or read to see if there is exculpatory evidence there.
I want to ask you about what we were talking about earlier on stream. We'll look for some more hashtag HeyJB, hashtag hey, or excuse me, hashtag the lawyer you know, or lawyer you know. I'll look for LYK too, just because it's the cool thing to do. The cool kids with LYK in our comment section, man. 51 terabytes. Peter, if you were my attorney and you were defending me, and 51 terabytes of evidence fell into your lap, your first gut reaction is what?
So you have a duty to go through it and see what's there. And you can't rely on whatever somebody else titles a document or a clip, right? You got to actually sift through all of that, which is why I think some of the motions to compel could be to specify or answer the question specifically. We've had cases that are incredibly document intensive, construction litigation or wrongful death cases with tons of medical records or medical bills. And certain discovery questions can say, do you have this? And I can't provide 100,000 pages and say the answer is in there. I have to actually provide the document or the answer that they are requesting. So it's one thing for the state to say we turned over all the evidence. It's another thing for them to specifically answer a well-tailored request for production or an interrogatory request from the defense. So that could be some of what they're arguing about, or the defense could have gone through everything and said, it's not here and we know you have it.
So is it gamesmanship between the two sides? Is any of that going on?
So we know that there are timelines that you have to produce this stuff, right? 30 days to produce 51 terabytes of documents and to go through all of those. Maybe the state's saying it was impossible. We don't have the manpower or woman power to go through all of this. So here's everything we have. We're not hiding anything from you, but we can't go through it and specifically pull out documents within 30 days. So we want to make sure we're within the rules. We're discovering this to you. We're producing it. Here it is. You can use whatever it is you find in there. We're an open book right now with you. It might not be gamesmanship at all. It might just be a timing and a manpower issue.
We haven't brought really this up on this live stream yet, but I know that I was following you a little bit on Instagram. You know, we follow each other. We're pals like that.
Oh, yeah.
Tanya says, #lawyer, you know, what did you think of Dateline? The timing it came out. And in Tanya's opinion, all the speculation, no facts. I'll get into this here a little bit too, but Peter, why don't you go first?
Sure. And I mean, I'm sure there were facts in there, but there was some speculation as well. It's TV. That's kind of part of what you get when Dateline runs an episode like that. They want to make it interesting. They want to make it captivating. And this kind of also relates back to the very first comment about how we try to bring the facts and not be biased or point one way or the other and just kind of tell you what's going on and explain the process. And I think that as we look at this, as we see the Dateline show, and then as we hear from the judge today at the hearing you just streamed here on WFLA, the judge said rights, and there's irreparable harm going both ways. Rights are being violated. The Sixth Amendment right to the Constitution that the defendant has in this case, irreparable harm could be caused by the media. And I think he may have even said is potentially being caused at this point. And he's thinking about, I believe, Dateline NBC, documentaries, news shows that are going on and taking speculation, calling it fact, condemning Bryan Kohberger, convicting him in the court of public opinion when he hasn't had his day in court yet. And regardless of what you think about his guilt or innocence, we have to understand how the process works and how we go through it, because the judge is going to look at that. He's going to look at this show, JB. He's going to look at mainstream media and say, how are they talking about this? If they're discussing it as they can't wait to hang this guy on the cross, he's not going to like that, and the gag order is going to be restricted. But if they're talking about it like you do, JB, in a way where this is what happens, what does it mean? What's the timeline? What are we looking at? What could standing silent mean? Those are the good questions. Those are, I think, what the judge would absolutely allow the media to talk about and would actually come forth with a less restrictive gag order. If that was how most people are talking about it, I just don't think it is.
I can't help but wonder if the gag order is making the gag order being as restrictive as it is, and reporters having to go through back channels for information, if that is contributing to the overall problem here. It almost seems like a cycle where we're all caught in this this laundry machine cycle of information that is going around, and it's also, is it compromising the process? That's something, of course, that a judge has to take into consideration when they look at how the public is falling in. And also too, we've talked about this so many times, how you go about jury selection in a case that is so mainstream. When everybody knows about it and everyone has formulated an opinion, that can make it very, very difficult to find an impartial jury.
Protecting the rights of the people in the courtroom comes first for the judge, and protecting that process. Then protecting the public and the First Amendment rights and what we all as the public have a right to is secondary. That's why it's a balancing act. Just because we want to know what's going on doesn't mean we're going to violate the rights of the criminal defendant or even the state if it's affecting the state. I absolutely agree with you. And it's not just in this aspect of life, but when you do restrict from legitimate information, people are going to go looking and searching and maybe reaching for less legitimate information. That absolutely can be a side effect. So how do you balance that? I think there's a way to write a gag order in effect that will allow things to be more open to the media while still not allowing interviews and, potential leaks from law enforcement or things that can be used or weaponized in the media to condemn people before they have their day in court or condemn some of the victims in the case. We've seen that going after victims. Why didn't they do this? That's what we have to be careful of, because everybody in the process needs to be protected.
Let's go to this question from Amber. Hashtags for us both. Now that he has, let's clarify this, because she's saying now that he has chosen a speedy trial, has he technically selected his right to a speedy trial? I mean, he hasn't chosen that, or has he? Would you verbalize it that way?
So I would say that he has not waived his right to a speedy trial.
Right.
And by not waiving your right to a speedy trial, you are saying that I get a trial in 6 months. That's how it works. Right. And if the state does things to delay the case, then they could say, we're demanding a speedy trial, and they're violating that right. But if the defense today would have agreed to a trial date next May, they would have in essence waived their right to a speedy trial and agreed to a trial date outside of the 6 months. Now, there are times where you can agree to a trial date next May and then later demand your right to a speedy trial and push the process quicker. There are pieces in place that have a shortened timeline that you can still keep your speedy trial rights, even though you've agreed to a later trial date. But many times, if you file the motion to continue or agreed to continue a case, there are things that can happen that are effectual waivers throughout the process, and they absolutely did not do that today.
And again, I want to reiterate, as Peter noted earlier, and I want to make sure, because there was some confusion in the comment section. You are saying that there is a 5% chance, in your expert opinion, a 5% chance that this trial begins in early October, right? And a 95% chance it gets delayed. Is that correct?
Yeah. And again, it's a pure guess. Okay. So I could say in your expert opinion, but I have no crystal ball on when this case is going to go to trial. And as you and I have talked about, I think we talked about the Petito civil case. We talked about when's that going to happen. I told you a 0% chance it happens whenever the first trial date was for that.
You're right.
So, and that one I felt much more confident. The reason I put 5% here is certain times in these criminal cases, the defense will think it's actually better to get this thing rolling, not let it fester, not let the public just continue to rise up. Again, we saw it in the Murdaugh case. We actually saw, in my opinion, even though Alec Murdaugh lost, there was some benefit to the defense that they did push it to a speedy trial because it made the investigation look that much worse. And in this case, by waiving a speedy preliminary hearing, the defense was able to do some discovery. So in a normal case, if they would have arraigned him immediately and done the grand jury indictment immediately, they would have had a lot less time to prepare than they've already had to prepare in this case. So that's why I put it about 5%, because I don't expect it to happen, but I don't put it at 0. That's for sure.
There is a strategy here, no doubt, regarding the timeliness of the trial and how the chips fall, if you will, is going to be fascinating, both from a prosecution standpoint and from a defense standpoint. But I want to really quickly, we have other comments in the queue, and we're going to be getting to Brian Enton here shortly. So I want to try to get as many as we can, because I know that Peter doesn't have all day to be able to talk with us. As far as the trial being pushed out a couple of years from now, I mean, 2024, 2025, real quick.
So one of the hard things is once you start to continue it, once you waive your right to a speedy trial, then sometimes it can snowball and you can't get it to go fast enough. So that's why it lasts years. I wouldn't expect this one to last 4 or 5 years though. No.
We know this name. Azam says, #HJB lawyer, and yeah, the golf emoji, which you see in Peter's chat all the time. Is the standing silent common during this process?
It is the least common plea, or if you're going to call it that, it's the least common approach. Usually you just plead guilty or you plead not guilty. But it does happen. It's not, unfounded or never happened before, so shocking. And that's why there is a place in the law that it just basically means the same thing as a not guilty plea.
Do you think it is more likely that he chose that for himself, or that it was under the advice of his attorney and Taylor to use that option?
I would guess it's under the advice of counsel, but he understand the process and probably want to make some decisions for himself and maybe use some quirky legal angles.
Right, because we're talking about somebody who is studying criminology or has studied criminology. So we have to remember Bryan Kohberger's background and how it fits in as far as how he devises his strategy. Not to mention also, he has had 5 months to think about this. I mean, the indictment was sudden and came, just last week, but at the same time, he's had a lot of time on his hand behind bars to think about, the different strategies that he might deploy given the likely outcomes that currently exist legally in this case. Let's go to Atharia. It's a pretty name. Hashtag lawyer. What could be exculpatory evidence except a solid alibi in this case, considering that they have his DNA at the scene of the crime? It's a very interesting question.
I mean, what could be exculpatory evidence is a pretty long answer. A ton of stuff could be. If one of the statements from one of the witnesses was that he was there, they were friends with him, and that's why he had a reason to be there. His DNA had a reason to be in there. One of the statements that somebody else, that there were multiple people in the house, that the DoorDash person is actually who they saw walk through the house. I mean, there's so much that could be exculpatory that it's hard to just pin down one thing. But it seems like if anything is exculpatory, most of it is pointing towards witness statements or timeline parts that could prove he didn't actually do this, which I don't know. We'll see.
Let's go to some others in our comment section while we have another couple of minutes. I'm just gonna put up this comment and just say, what are your percentage odds on the change of venue? How about that? Because this question, while it is asked in a hilarious way, what let's just focus on the question itself.
Sure.
The percentage chance of a change of venue.
I would put it at 50-50. We've seen stuff like this already happen in Idaho. We know the media attention on this is going to be next level compared to Lori Vallow, which was the last case that was in Idaho. That was big, that there was a change of venue. So I really put it at 50-50. Most cases are much, much less of a chance of a change of venue. That's actually a really high percentage chance of a change of venue.
That previous comment, by the way, is again proof I don't ignore. I'm always looking for the best comments, regardless.
Hey.
Yeah, just trying to get the best quality content possible here. Peter knows what I'm talking about. Low Country hashtag hey Laura, do you think Bryan Kohberger is working on his own defense?
The only thing that would make me say no to this is Ann Taylor has conflicted off other cases kind of in a public way. She seems to be a good public defender, death penalty certified. She seems to be fighting for him. All of those are indications that they're working together. I don't want to say lawyers don't work as hard when a client's a jerk and wants to represent themselves and is demeaning them throughout the whole process. We've seen clients like that and cases like that in a high profile nature. So right now I would say no, but it's definitely something that we're going to have to follow into the future just with his background.
I'm going to the notepad. As we look here, this is a replay, folks, of the gag order feed, as I understand it. And as we look here at John Judge, the judge in this case, I want to bring up this one point. He paused when he was reading the names during the arraignment this morning, Peter, and he paused and he said, "Sorry, this is hard." As he was going through the names, some were noting about the pronunciation of some of those names in our comment section, but he seemed to pause a bit and even apologize to the court. Is there anything? We're seeing this judge really for the first time in this case. So what do you make of him and his hearings today, including the arraignment?
Well, just in the very short time I've had an opportunity to observe him, he seems like the type of judge that is going to make a call, is going to say what he thinks. Some judges don't. He is going to tip his hand a little bit, like I think he did to the media, and how he talked to them about their motion and what he found frustrating in it, or that he disagreed with in it, when he said, "I don't mean to teach you, but you should know what it means when a higher court has a holding, and that was not it. And you called it a holding in your motion," when he talked to the media's lawyer. I think that he is the type of guy that's going to show a little more emotion as a judge than we may be used to in some of these other cases. And I think that was an indication of it when he was reading the names and kind of just understanding the gravity of this situation, which it affects everybody. Anybody that understands what happened, that does not mean he thinks Bryan Kohberger did it. For him to think that what happened here is sad does not mean this is the guy who did it and I'm going to make sure he gets convicted. Not at all. It just means this is a sad situation and everybody understands that.
Mortar says, "Hey, lawyer, I noticed that when he paused, there was audible crying in the court. I think it might have made the judge emotional." Peter, we got to let you go. We've got Bryan Enton standing by next. Peter, I know you're going to be doing live streams on this. Where can people find you?
So on YouTube, Lawyer You Know is our YouTube channel. If you want to check out any of the videos we've already made or lives that we're going to do, hit the reminder bell because we kind of do them at random times whenever I can. At Tragos Law on all other social media platforms, Instagram, Twitter, etc. Would love to talk to you guys about the case, and I'm sure I'll be back here to hang out with JB some more.
Yeah, Peter, I always appreciate it, man. I enjoy our live streams together. Thank you so much, and good luck on your lives as well as you continue to cover this case.
Absolutely, and Brian's awesome, so enjoy him while you have him.
Yeah, we got 10 minutes with everybody. Bryan Enton. In fact, let's bring in Bryan Enton now, joining us from outside the Latah County Courthouse. Hey there, Bryan. Good to have you back on stream. You were in there. We were following your tweets every step of the way over the course of the arraignment and then the subsequent hearings that took place as well. How you doing today? And what's the latest from Idaho?
Yeah, hey, sorry, I wanted to be able to get live with you before the hearing, but it was so crowded outside. There were so many people lined up, and then it was kind of like a rush to get inside. It's such a small courtroom. I would say only like about 50 seats or so, and there were 25 family members that took up half the courtroom. So I was just so focused on getting in there, I wasn't able to come on with you this morning. But yeah, we're just outside now. Things have sort of settled down. You can imagine it was kind of crazy out here earlier.
You got leave it to Bryan Enton, everybody, to apologize to us for not being on earlier. It's great to have you on now, Bryan. So let's just talk about the case. I mean, everything was very procedural this morning as far as the arraignment, but a lot is being made of his choice to stand silent. We just had Peter Tragos, a legal expert who comes on stream with us quite a bit, and he said that is not something that you see very much as far as that legal option. What has been made of his decision to not verbalize his own not guilty plea?
Yeah, I think it was kind of a striking moment. I think most people expected them to say not guilty. I think there's probably like some procedural reasons, and Idaho law has some strange things that are different from other states. I was actually just before this trying to talk to an Idaho attorney who I talk to a lot, who I haven't been able to get on the phone yet. But I mean, clearly his intention at this point is that, to plead not guilty, that he thinks he's not guilty. I don't think they would have talked about the trial the way they did, going back and forth, picking the date, planning on having a trial at this point. But yeah, I mean, it surprised me. I think most of us expected, to hear the words not guilty out of his mouth, not out of the judge's.
As far as judge and his pause there in court, you were there. We've been talking about that moment where he had to just he apologized and said that this was hard for him. What was going on during that moment as the victims' names were being read aloud in court in today's arraignment?
Yeah, he definitely messed up some of the victims' names, several of them, and said Kayla instead of Kaylee. And I don't know what was going through his mind. I mean, obviously I was sitting there looking at him, but I don't know if he was emotional or just nervous. I mean, obviously it's a small courtroom. They don't deal with a lot of hearings with, so much media and that kind of a thing. But it definitely frustrated the families. I mean, you could, because it wasn't just one time, and you could kind of see the look on their faces. And then afterwards, I heard several of them saying that they thought that it was disrespectful. But, emotions are already just so high. In there, it's so small, JB. I don't think people realize, because you just see that one camera angle, but it's a very, very small courtroom. So where the 25 family members are sitting is very, very close to Kohberger. And I think that everybody is very, very tense, in there.
Yeah. And of course, there also is the element of the gag order as well. And Gonzalez's family, I mean, they are, of course, frustrated with the gag order. We, of course, read out the statement from the family that you tweeted out. Have you had any additional conversation with them or the families of the other three victims as well in relation to their reaction to seeing Bryan Kohberger in that courtroom today? And now that we have a trial date, even though there's always the chance, and according to Peter Tragos and others, there's a chance that gets delayed, perhaps even into 2024. As we get as we hear from more people, where does this go from here, Bryan?
Well, you bring up the gag order. So they've not made a decision. The Judge John Judge, his last name is Judge. They haven't made a decision on that yet. They sort of pushed it off today, which is frustrating to Kaylee Gonzalez's attorney, because the way it's written now, there's a big question about whether he's even allowed to speak to the media. And that's why he hasn't, because, it could be a violation. And really his job is to speak to the media so that the family doesn't have to be the media spokesperson. So he's looking for clarity so that he can start doing that job again. And now he'll have to wait. So that's one component of it. The other component of it is the media coalition, which is sort of headed up by the Associated Press, has filed these complaints saying that the gag order is too strict and there's not enough public information. So the judge also didn't rule on whether he's going to make the gag order more lax. That's all going to come up at the hearing next month. So that's all to be continued. In terms of how the families are doing, I haven't spoken to the Gonzalez's at all, besides a couple quick texts about Olivia, Kaylee's sister's baby, just being really, really cute, because that was just an interesting moment in court that I haven't really seen before, wasn't expecting. Last time I interviewed Kaylee's sister, Olivia, she was pregnant. Well, she's now had the baby, and then she brought the baby to court in this sort of, I don't know what you call those things, like a coddle or whatever you have, like where you have the baby on the front of you. And so, there was sort of like the baby cooing noise throughout court, and you could tell that it was like the baby was really comforting the family. It was just a really kind of interesting, emotional dynamic having the baby there. And I think just added to the sort of just rawness of the whole experience inside that courtroom.
High emotions for sure. Especially, you could just tell we were listening on live stream, or at least after the delayed feed came out, just how everything in the room felt like it changed when we started to hear Kaylee's name and Xana's name and Ethan's name and Maddie's name. It was just, it was a moment for sure, because it brings everything back, of course, the 4 victims in this case. Bryan, do you have a free 5 minutes for just some questions before we let you go?
Yeah, sure. Yeah, I think so. Yeah.
Okay.
Yep.
Hashtag, if you need to hop off, you let me know. You know how it works. Hashtag Hey Bryan, hashtag Hey JB. If you use one of those hashtags, we can take it to News Nation senior national correspondent Brian Enton. James says hashtag Hey Bryan. And this is for you, as far as your observations. Any surprises for you in court today?
No. I mean, the fact that they set a trial date, I wasn't fully expecting. Of course, like you said, from some of the guests you've had on, that can change and can be delayed, and who knows what will really happen. But they did seem confident when both sides agreed on the October 2nd date, and I wasn't really expecting that. So that was kind of a surprise. Again, just just the eeriness of being in there. Honestly, I'm in Florida too most of the time. I'm from Florida, like you, JB. I'm used to big courtrooms. There's just something when you're in a space that small with an accused killer and the families. That's just weird. So that it didn't surprise me, but was just it's a strange situation. In terms of, a lot of people have been asking me, did Kohberger look different? From the last time I saw him, he looked basically the same to me. Maybe his hair was a little longer. I mean, just a minor thing. And he has some sort of protective vest or something on underneath his jumpsuit, so he did look kind of big. But I think he's very skinny. That's just the vest. But yeah, those were sort of the things that stood out to me.
And also, too, while I have you on stream here, Bryan, was there any video that you and the News Nation team captured of him leaving the courthouse, or is he still at the courthouse? Has he been transported back to jail?
Well, it's interesting, JB, because again, I don't think people realize how small this community is. I mean, the courthouse is 2 courtrooms, very, very small. The jail where he stays is under the courtroom.
Okay.
Right in the same little building. There's not a lot of cells down there. So they just bring him up some stairs and he goes to the hearing, and then he goes right back to the basement.
Got it. I didn't know it was that close as far as on the premises. Let's go back to the questions that are coming in from people. Colin wants to know, and we'll go here to this feed. Oh, hold on one more second. There it is. Colin says, hashtag KJB, hashtag K Bryan. Is it true that Olivia complained to victims' rights about the name pronunciations? This is a good opportunity for us to try to, again, some of the social media chatter out there, clear up misinformation, do our part as journalists to set the record straight. Have there been any complaints formally, put forth about the name pronunciations by Judge?
Yeah, I don't think it, at least from what I could tell, was a formal complaint, but she did say something when the hearing ended, just sort of in her group, and there was also what appeared to be like a victim's advocate there. But I don't think it was so much as a formal complaint as just being sort of frustrated that that the name pronunciation wasn't right.
Let's go to some other comments that are coming in. Allie wants to know, hashtag Hey Bryan, why do you think the Kohbergers didn't show up today and say, Allie is giving her opinion in the comment as well, saying, I think they want to avoid the media, but it must be hard for Bryan Kohberger not having them supporting him in court. As far as the Kohberger family and communication with them, even in all these months since January when we last saw Bryan in court, I mean, what have we heard? And do we have any understanding as to why they haven't been or why they weren't here today?
Yeah, so they were in court initially in Pennsylvania when he made his first appearance. And it's my understanding, and I haven't had any new information in probably a couple of months. But the last that I had information from that side, it was that they are not in a good financial situation. This is obviously a long way from Pennsylvania, so there would be money involved to get here. So that could be a component. You mentioned, I mean, the media, although they were there in Pennsylvania, and there was probably more media at his first appearance, and they made the decision to be there. So I think it could be a financial issue. I've reported in the past, and I think the situation has also changed. But at one point, his sisters had lost their jobs. And it obviously not easy being Bryan Kohberger's family right now. So I think all of those things probably contributed.
Brian Enton of News Nation joining us here, everybody, on WFLA now. Brian, just really quickly, I always ask you at the end of our streams, how you holding up? Life treating you okay? I know a lot of people always follow you for your reporting, but also just because, what they think of you as being a stand-up guy. How you doing out there in Idaho?
Yeah, thanks for asking. Yeah, no, I'm doing okay. It's weird being back. I was just talking to Lauren and Luis, who are out here with me. It's weird being back here just because we were here for so long, for I think over a month at one point. And, it's just weird being back in Moscow, seeing all the same places. It's kind of a sad feeling. The weather is a lot different. It's warmer, which is nice. But again, I don't know. The whole courtroom thing today was really just strange and emotional for the families. And that's kind of what I'm hung up on, just being in that room, being so close to them and close to Kohberger, all in the same spot. It's just a very, very, you just can't imagine what they must go through, how they're supposed to process that.
I can hear it in your voice, and I can assure you the camera doesn't do it justice as far as how small this courtroom actually was. It definitely, without question, based on what you're saying and your account of it, it definitely looks bigger on camera than it does, I'm sure, with how it felt in that room today, especially when you're talking about it being, jam-packed with people. Brian, we really appreciate it. Everybody, please give a follow. You probably already do if you're watching this live stream, but please give a follow to News Nation's Brian Enton and pass along our best. Brian, I know that you're with a great team out there from News Nation. We appreciate you taking the time.
All right. Thanks, JB. Have a good day.
Yeah, you as well, Brian. All right, back here with you live, folks.
Well, there you go. That was the gag order hearing. And the trial is set for October 2nd. They're going to have the gag order hearing for the media on June 7th. Or no, I'm sorry, June 9th. And then June 27th will be the other hearing for the defense and prosecution. I'm not sure exactly what that hearing's for, but that's that. All right, have a good day. I'm out.